Good morning. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions. For those in-house, we would ask that courtesy to see that our mobile devices are silenced or turned off. And of course, for those watching online, you're welcome to send questions or comments at any time, simply emailing speaker@heritage.org. And of course, we will post our program on the website for everyone's future reference as well. Leading our discussion is David Burton, who serves as a Senior Fellow for Economic Policy in our Institute for Economic Freedom. He focuses on tax matters, securities law, entitlements, and regulatory and administrative law issues. Prior to joining us here at Heritage, he served as General Counsel at the National Small Business Association. He has also been Chief Financial Officer and General Counsel of the Alliance for Retirement Prosperity and was a partner in the Argus Group, a public policy and government relations firm. Please join me in welcoming David Burton. David?
Thank you, John. Good morning. Our subject today is beneficial ownership reporting. But first, a couple housekeeping things. Karen Kerrigan will be unable to join us. She, like a lot of people, has been temporarily felled by the flu that's going around town and will be unable to join us, unfortunately, this morning. What we're going to do is have our two panelists talk for 10 or 12 minutes and then open it to audience questions and answers, and hopefully we can have a bit of a discussion. Let me take a moment to frame the issue and also introduce our two panelists. First, there are three pieces of legislation. Two have actually been introduced, and one is a discussion draft that raised this issue. The first is H.R. 3089, introduced by Representative Carol Maloney. It's called the Corporate Transparency Act. The second is S. 1454, the Title Act, which stands for True Incorporation Transparency for Law Enforcement, and that was introduced by Senator Sheldon Whitehouse. The third was the subject of a hearing on November 29th. It is legislation that deals with this issue, specifically Section 9 of that legislation deals with this issue, but it also deals with a number of other issues. That has not been formally introduced, but a discussion draft has been released, and it's called the Terrorism and Illicit Finance Act. The hearing was a joint subcommittee hearing of two subcommittees, and each of the two chairmen, Representative Pierce and Lukemeyer, released the discussion draft. Now, what all these three pieces of legislation with respect to beneficial ownership reporting are almost identical. And what they would do is impose a general requirement that businesses report their beneficial owners, their true owners. And then each of the legislation has a series of exemptions. What they would do would require that when a business is formed or ownership changes hands or you get a new investor, you would have to file a report with FinCEN. With respect to the exemptions, FinCEN is the Financial Crimes Enforcement Network at Treasury, for those of you who are unfamiliar with that. And if ownership changes, you would have to file an updated report within 60 days. If you don't, you're subject to massive fines and up to 3 years in prison. The bill, or each of the bills, has exemptions. And this is the thing that's most remarkable about it to me. They exempt banks, insurance companies, credit unions, tax-exempt organizations, governments, and every employer with 20 or more employees. So when you think about it, what's left over? Firms with less than 20 employees. The shopkeepers, the dry cleaners, the restaurant owners of America would be the only ones subject to these onerous rules. And as our two panelists are going to get into more detail, the rules are not simple. There's massive ambiguities and difficulties. Now, call me an idiot, but I do not believe that the nation's shopkeepers, dry cleaners, gas station owners, and so on are the largest national security threat that we face. And to the contrary, I suspect that they're the least. The people who can actually undertake money laundering with some ease are exempt under all these pieces of legislation. More relevantly, or as relevantly, the legislation applies only to corporations and LLCs. Now, money launderers typically are not stupid people. So all you have to do to not be subject to these rules are to form a partnership, such as a limited partnership, or a business trust, and you're not subject to these rules. So quite literally, in my opinion, this legislation will do nothing to further law enforcement objectives. What it will do is create tens of thousands, and eventually hundreds of thousands, of inadvertent felons among Main Street businesses who didn't know that they were required to file a form with FinCEN. And they'll be subject to potentially 3 years in prison. Now, one more thing I thought I'd mention that not too many people have mentioned, the government has almost all this information in its hands today. Most small businesses are pass-through entities. They're either S corporations or LLCs, and some of them are partnerships. They have to file either a Form 1065 or Form 1120S with the associated K-1s, which report to the government through the IRS who owns the business. So this is not only going to be ineffective, it's duplicative. Now, this legislation, it sounds relatively straightforward, but as the panelists will get into, there is a tremendous amount of ambiguity and a lot of due diligence requirements, but it requires the business owners, when they sell their business to their cousin or their neighbor, to get a driver's license or a passport, and then have lots of other information. And if they don't happen to have one of those documents, there's a whole series of additional rules. There's also a lot of subsidiary issues as to, because it's not true ownership, it's also control as to what the legislation really means. But in the final analysis, all these proposals would be to impose a massive paperwork burden on the smallest businesses in America, and it would achieve nothing in terms of enhancing our national security or the safety of the American people. Now, allow me to introduce our two panelists. As I mentioned, Karen won't be able to be with us. Brian O'Shea is the Senior Director at the Center for Capital Markets Competitiveness at the U.S. Chamber of Commerce. It's his second tour of duty with the Chamber. And Brian is one of the more thoughtful and effective advocates for small business capital formation in Washington, and I've enjoyed working with him over the years. He was previously senior advisor to Representative Scott Garrett, who was chairman of the Capital Markets Subcommittee until the end of the last Congress. He's also served as legislative director to Representatives Ann Wagner and Kiko Kanseco, both of whom are members of the House Financial Services Committee. Earlier in his career, he worked 6.5 years with Morgan Stanley. He has a BS in economics from Virginia Tech. Go Hokies. My daughter went there too. Caleb Kronkenberg is the white-collar crime policy counsel at the National Association of Criminal Defense Lawyers. He works on over-criminalization and the erosion of meaningful mens rea requirements, two issues where the Heritage Foundation has also been quite active, specifically Paul Larkin. He began his career as an assistant district attorney in the Appeals Bureau of the New York County District Attorney's Office, and then as an assistant public defender for the state of New Mexico. He later transitioned to serve as an assistant federal public defender for the District of New Mexico, and most recently worked as a criminal defense and civil rights lawyer in Philadelphia. He received his JD from Temple University and his BA from the University of Kansas. We're going to go in the order of Brian first, and then Caleb. Brian, you can either take the podium or do it directly.
Might just do it right here if that's all right. Thank you very much, David, and thanks to Heritage for hosting this event. I really appreciate the opportunity to talk about a very important issue. First thing I want to emphasize is, probably a lot of you and a lot of people are hearing about this issue of beneficial ownership reporting for the first time. It's something new. It's gotten a lot of attention recently, whereas it hasn't in the past. But one thing I want to emphasize is that this is an issue with a relatively long track record stretching back about a decade, and the Chamber has a very long history of positions regarding it. There have been bills, primarily in the Senate, going back to about 2008 or 2009, that would mandate beneficial ownership reporting, and those bills still exist today. And so we have kind of a very long track record on this issue, and while it's new to a lot of people, a lot of the fundamental problems and issues that we've had with some of the proposals being put forward today still remain. And so all my comments today, I'll focus not solely on the draft discussion bill that came up in the House last month or back in November. I know that's gotten a lot of attention recently, but I'll kind of talk about beneficial ownership reporting and the concept of it writ large, because a lot of the bills floating around Congress are substantially similar. And another thing I want to note at the outset is there's been a couple of articles recently about this idea of government collection of beneficial ownership data and how there's bipartisan support for the concept. But one thing I would note is that there has historically been strong bipartisan opposition to the idea as well, and there continues to be. So there have been concerns raised by members of both parties in Congress over the years as some of these proposals have been put forward. So I'm going to take my comments this morning into three parts. One would be to give everybody an idea of the scope of these proposals, who exactly would be affected by it, who would be mandated to report beneficial ownership information under them, and who would ultimately pay the costs for the requirements. The second would be to walk through a bit in detail what exactly would be required of small businesses to report, and the types of due diligence, the types of looking through other entities they would have to do in order to accurately report information to either a federal agency or to states, depending on the proposal, and not become subject to prosecution for getting something wrong. And then the last thing, I'll talk a little bit about our obvious concerns over the penalties for noncompliance that are included in some of these bills. I know Caleb will talk about that in a lot more detail. But then also just the general concern of what this means in terms of government collecting a lot of information, a lot of new information that it doesn't collect right now, and the problems that can arise from that. So the first thing, the scope of the proposals in Congress, who would have to comply with these, and David touched on this a little bit. But all of the bills put forward, as David described, are literally only the smallest of businesses in America would have to comply with these. So as long as you have fewer than 20 full-time employees and less than 5 million in gross receipts, and you do not meet one of the exemptions that exist within the bills, if you're a public company, if you're a bank, if you are a credit union, if you're registered with the SEC, you are required to comply with the requirements in the bill. So you essentially have this situation where large entities, large institutions are exempt. The smallest businesses in America are the ones that have to comply. One of the things that struck me as we have had several meetings on the Hill and with others about these proposals is we often hear, whenever we bring up this concept, we often hear back from people, oh, you're talking about the shell company bill, or oh yeah, that's the bill that would require shell companies to report certain information. And we have to remind people that no, this applies to every operating, legitimate, law-abiding business who happens to have fewer than 20 employees and less than 5 million in gross receipts. So millions of American businesses who, as David said, pose no threat to national security, or other problems would be the ones subjected to the requirements under the bill. It is not just something that applies solely to shell companies, however that would be defined. And to state the obvious, pizza shops and dry cleaners don't have large compliance departments. And as I'll get into in a second, some of the complexities that they would have to deal with in this, it would be very difficult for them to report a lot of this information accurately. So the second thing, so what exactly would a business have to report either to FinCEN or to their state authorities, again, depending on which bill you're talking about in Congress. All of them introduced these new definitions and new concepts of who a beneficial ownership is. And the definitions that are used are an individual that directly or indirectly benefits from the assets of the corporation, or directly or indirectly exercises substantial control over the entity. Both of those terms are not something that any small business owner has had to grapple with before or consider, well, who involved in my business may possibly meet the definition of beneficial ownership under these very vague and ambiguous terms that, to my knowledge, don't exist anywhere else in statute. And again, you're talking about applying this to people who have not had to report any type of similar information before. So one thing I would note on that, the vague definitions included in these bills stand in stark contrast to other definitions of beneficial ownership that have been put forward by federal agencies. So I'll get to this a little bit later in my remarks, but FinCEN last year finalized a customer due diligence rule, which is a very flawed rule, is very far from perfect, but their definition of beneficial ownership and what was required to be reported was one controlling officer and then anyone within the entity that has a 25% ownership stake. So there was a finite amount of people that a business knew that it had to report in terms of who was the beneficial owner, whereas under these vague definitions, there's essentially no limit on who somebody might have to report. And in a lot of cases, if you have somewhat of a complex business structure, those entities are going to have to hire outside counsel to figure out exactly what their compliance requirements are under these bills. Another issue with, and another requirement that's under all of the proposals put forward is a requirement for a business to look through other entities that may own a stake in that business and report all of the beneficial owners of that entity unless that entity which owns a stake meets one of the exemptions that I described earlier. So the example we use with this is if you think of a startup technology company, maybe it's got 3 or 4 employees, and they're desperate for startup capital, and an angel investor or somebody comes along and is willing to make an investment in that startup company. What the company basically has to say to that potential investor whose money they are desperate for is the only way we are going to accept your investment in our company is if you provide me with all of the beneficial ownership information of your entity. And by the way, if any of that changes within 60 days, I need to know that too, because I am obligated under federal law to report that up to a federal agency. So not only does this affect the pizza shop, dry cleaner, kind of the corner small businesses in the country, but from a capital formation standpoint, it's extremely inhibitive. It's going to make it much more difficult for startup, innovative firms to raise the capital that they need, whether it's from angel investors or, if you have, somebody that has an idea and they've set up an LLC and they're looking for money from family, friends, neighbors, you could have potential, 15 or 20 different investors that you, in a lot of cases, might have to look through and figure out what your reporting obligations are under the bill.
God forbid they do a crowdfunding offer.
Or, yeah. So, when you start to peel this back a little bit and, and you start to realize what this would mean for a company that's just getting off the ground and is desperate for investment, it's going to make it much more harder for them, for those types of companies to raise capital. And then the other requirements as well, I mentioned the 60-day reporting requirement, which if there's any change in the beneficial ownership information anywhere in the corporate structure, that has to be reported within 60 days, which, number one, is a very short time frame, but number two, the requirements are 60 days after any change occurs, not 60 days after the business finds out about the change, but 60 days after any change occurs. So think of a case where there's a business and maybe one of the employees has a stake in the company, and it's a common law state, and that employee goes through a divorce. And as part of the divorce settlement, that employee's ex-spouse now becomes, under the proposals, a beneficial owner of the company. One, the reporting business may have no idea that any of that took place, and they certainly within 60 days might not know that they have to report that information. But two, in that case, they have to go to their employee and say, hey, can you please reach out to your ex-spouse and send her or send us her name, address, and passport or driver's license information. So there's all these kinds of complexities that could arise from what exactly is required to be reported under this bill that we think Congress and others really need to take under consideration. And so the third thing I'll mention, and as I said, our concerns over what it means if you get something wrong, what it means if you forget to file within 60 days or file the wrong information, or if you forget to file the annual report or the annual update that's required under the bills. And as David described, I think it's the same across all of the proposals, but you would be subjected to a $10,000 fine and up to 3 years in jail. So you also have this threat, this kind of albatross of potential federal, violation of federal law and prosecution hanging over your head if you happen to get any of this wrong, and if a prosecutor thinks that you did it, in some cases knowingly or willfully. And then, to kind of state the obvious of what this means is a lot of this information, based upon the definitions of beneficial ownership in the bill, is not collected right now by federal agencies. David mentioned other information, controlling officers through certain other forms is collected. But if you have a case where it's a startup or a small business that has a complex corporate structure, and they might have to report the names of 15 or 20 individuals, you're talking about a massive new influx of data and sensitive information that the government is collecting that, of course, is going to be vulnerable not only to cyber attack, but to potential misuse by federal employees. And that raises another concern that we have with the bill, is that while there's a penalty for businesses who fail to comply with the requirements, there is no concurrent penalty for federal employees or government employees that may misuse the information that's collected under the bill. So those are kind of the three ways I want to describe exactly what this means for small businesses and the complexities that it's going to create for millions of entities across the country. Just to add a couple more things, and one is, and this is a very important consideration, part of the reason why beneficial ownership, that this is really becoming kind of a hot issue right now, is I mentioned earlier, FinCEN finalized customer due diligence rules for banks last year that are set to go into effect in May 2018, so in just a few months. Those rules, as I said, are very far from perfect. There's a lot of flaws with them, and in a lot of cases, they could cause banks to not take on customers that they otherwise would. And we completely understand the concerns. We've shared those concerns that a lot of people have, and we fully support any kind of fix to CDD rules or any kind of way to assist financial institutions and banks with their compliance. But we've always cautioned that the right answer is not simply shifting this burden onto millions of unsuspecting, law-abiding businesses, particularly in a manner where you're going to require of them very kind of confusing obligations that they are not prepared to handle. So, from our standpoint, we are certainly willing to work and willing to address any of the issues with the CDD rule. We have just cautioned going against this kind of blanket data collection approach that's embodied in a lot of these proposals. And then just the last thing I will mention is there's been a lot of other countries that have adopted similar types of beneficial ownership reporting regimes. And one point that we've always made is places in Europe and places around other places around the world don't have the type of capital formation ecosystem that we have in the United States. If you look at Europe, it's primarily bank lending. They don't have the type of venture capital, angel capital, early investment, private capital formation economy that we do here in the United States. And I think anything that is done in this area has to be reflective of our unique and dynamic economy, and not necessarily modeled upon what may work in other countries. So I'll stop there, and there's plenty more to talk about. But
And I just want to say thank you also to David and to Heritage Foundation for having me here. Certainly NACDL has been keeping track of these bills through the years. As Brian said, this is something that keeps coming up. And our concern as a criminal defense organization is really that these beneficial ownership bills in all their forms really typify the over-criminalization movement. And what I mean by that is there's this sense that Congress will decide they want a particular piece of information, and here it's ownership information, and they'll set up these rules, and then for some reason they can't help themselves, criminal penalties to any error, any sort of paperwork error in these new rules is now a felony. And I think when we look through these bills and these vague requirements, it's really concerning for people. There is a real threat that people can become criminals no matter what their intentions are, and despite their best efforts to follow the rules as best they can. And I know Brian mentioned the definition of beneficial owner, and I think that's really one of the main problems with these kind of pieces of legislation. All the different bills have different definitions, but really the consistent theme is it's anyone who has an ownership interest, directly or indirectly, or any other way of controlling the business. One of the most recent bill, the Counterterrorism and Illicit Finance Act, actually takes it a step further, and they say anyone with a direct or indirect control of the business, or anyone with substantial economic interest, and then defines a substantial economic interest as anyone with entitlement to funds or assets, or that, quote, as a practical matter, enables the person directly or indirectly to control, manage, or direct the corporation. And if you can sort of follow that definition through all the different twists and turns, really what you're talking about is anybody who derives a benefit, no matter what, and anybody who has any control, no matter what. And while we could disagree about who that might be, the real issue is that as someone who's forced to register, who do I have to list? Who derives any benefit from my corporation or my LLC, or who has any control whatsoever? And so what you're asking is for the people who are applying and providing this information to the government, they have to make a judgment call about, to their best ability, who do I think might benefit from my company? And I'll have to provide the best answer I can give you. And when we raised this issue with members and also during the hearings about these bills, one of the sort of consistent themes from the proponents is that there's the sense that they would like to keep the definition as vague as possible. Because to their mind, this is an effort to try to combat money laundering and hidden money and all these sort of things that are understandably that we don't want in our system. But the refrain constantly is, if we define it in a way that people understand their obligations, then the criminals will just provide all the information they're supposed to, and they'll evade the rules somehow. And so we won't be able to get at the real criminals. And so the sense is, that way we can make it say whatever we want to say, and that way we can get to everybody. But what I haven't heard, and what our problem is that the people who are filing the paperwork don't know the answer either. How are they supposed to follow the rules if the regulators don't even know what they mean? And the regulators say, we don't know what they mean, so we can get anywhere we want to. Now, when we take that vague definition and then we think about the criminal penalties, that's really when we get into a real problem. One of the criminal provisions in I believe every version that I've seen of this legislation penalizes anybody who knowingly provides, quote, false beneficial ownership information. And so we see the word knowingly and we think, well, maybe this means that a person can only go to prison if they do something on purpose, if they mean to violate the law. And the problem is the way that the statutes or these bills are written, it's the act of knowingly giving information. It's not knowing that the information you gave is false. And while that might seem like a very technical distinction, in criminal law, that's a huge problem. Because what the courts will most likely interpret this to mean is that if someone gave the information believing that it was true, but they knowingly gave the information to regulators, and it happened to be false, most likely that is a violation of the law. And if that's a violation of the law, the person is a felon, no matter how much they tried to comply, no matter how much they tried to find the information they were supposed to get. And this isn't just a theoretical kind of an interpretation. In the white-collar crime space, we see a lot of other kinds of statutes that are written this way, and courts routinely interpret them that way because they presume that if legislators wanted some sort of higher requirement, then they would have written it that way. And what ends up is you really have regulators with unlimited leverage over small businesses, because no matter how much a business might want to comply with the law, no matter how hard they try, chances are they're going to get something wrong. Maybe they missed a beneficial owner, or as Brian said, when the information changes, maybe they didn't even know the information changed and they didn't update the form. And if they still provided the false information, then they're subject to felony liability. And that gives the regulator really the leverage to do whatever they want to. Certainly they could send people to prison, and we could see that. But even more so, we could see fines, we could see, really the regulator gets to do whatever they want to do to the business. One of the other aspects of all of these bills that's very concerning to us as well is that they apply to any existing company. And so when you read the bills, it seems sort of at first blush that as long as you have this information when you're forming a company in the future, then you can comply with the rules. But these bills apply to any company, any existing LLC, any existing company. You have to update the information once the bill's passed. So what you're asking is any small business, any bakery, anything, you're saying you have to go find this information, you have to update it, and if you make a mistake, if you give us a false information, whether you knew it was false or not, you're a felon. And so really what we're talking about is it's almost impossible to comply. It's almost impossible to comply perfectly. And so regardless of any sort of policy implications about whether or not this is something that the government should be doing, the execution is such that the only people that are going to be caught up in this are people that just made mistakes. The real sophisticated criminals, the money laundering organizations, they're not going to be the ones that are targeted by this bill or any of these bills. And so that's really what our concern is. And as I said, this is just another step in this over-criminalization effort.
And just to make one additional point that Caleb reminded me of, so it came up in the House Financial Services hearing back in November where a member asked a question of the witnesses, and he said, hey, in my state, I've looked at our state incorporation forms. There is no box to check anywhere on these forms to say that I am one of the exempt entities that exist under this bill. So states, presumably, probably every state would have to redo, their forms process, but also companies would have to, as Caleb said, refile, whether they're going to file, and have to register beneficial owners, or whether they want to claim exemptions. They're going to have to go back through this process. So from an execution standpoint, when you're talking about how is this going to implicate, state corporation processes in 50 states, that's a big question as well.
All right, thank you. At this point, let's open it up to questions. Please identify yourself and your institutional affiliation.
Fan Knight of the Cato Institute. I haven't followed this very closely, so I'm wondering if you could fill in some gaps for me. I'm assuming that this is trying to close some sort of loophole and other way. And is the argument that look, we're going to cast the net very broadly and rely on prosecutorial discretion? I don't see lawmakers mom and pop argument on the other side for why this isn't a problem, or have they just not realized that this is going to have these effects?
One thing that I've heard as the justification for the exemptions is that larger corporations and other entities that are listed have existing obligations. So for like publicly traded companies, you have to list certain ownership information. And so the argument has been, well, we already get that information from these entities, so we don't need it. I would push back on that notion because the information that we gather from those other companies has very clearly defined limits, and that's something that Brian mentioned earlier. When we're talking about the other rules, there's a 25% ownership stake, things like that. We know how to comply with that. And so really these very vague definitions seem only to be targeted at these small businesses. And the other issue, I think, with prosecutorial discretion, certainly people have mentioned that to me, is that, well, certainly regulators wouldn't take this expansive view that you're viewing. And respectfully, I just disagree with that. In my perspective as a criminal practitioner, I think what can happen and what happens a lot is that prosecutors institute an investigation for a variety of reasons, and they may not find what they want, they may not find what they're looking for, but they can find very technical violations of law like this with very significant penalties, and they can exact whatever outcome they want, regardless of whether there's any other underlying activity, criminal or otherwise. So that's I think, what's going to happen.
Yeah, I would just add a couple of things. One is when Carl Levin first introduced, was the first one to introduce the beneficial ownership bill back in 2009, the 20 employee and $5 million in gross receipts threshold, we're not entirely sure exactly where that came from, but that was just decided as the proper threshold to try to get at these shell corporations. And so, that brings up the issue of what law enforcement is trying to get is they're saying, we cannot get access to the owners or who is behind certain corporations. But as both David and I mentioned, there are already other forms that entities have to file to open a bank account to, establish a corporation that are already on file. Is there, some way that, we can use that existing system in order to take care of any of the blind spots that are out there?
And let me just add one more thing. Is the existing requirements are primarily a function of the know your customer due diligence requirements of financial institutions to open banks. With respect to public companies, which is, of course, a pretty small universe of companies in terms of numbers, that information is available but it's holder of record, not beneficial owner. And there's been some talk over the year of moving to that, but most people here probably don't know that. But a holder of record means that everybody that owns, say, Exxon stock through Merrill Lynch is scored on Merrill Lynch's books as one shareholder, Merrill Lynch, its street name. And then you have to look through Merrill Lynch, but that's only available if somebody subpoenas Merrill Lynch's records. For private companies, for example, Facebook or any other large private company, Coke Industries, take your pick, they don't have to provide this information with respect to beneficial ownership narrowly construed, except on their tax returns. And that's basically what most people would think of as ownership, not what these bills have. And then it's a tax number, not a driver's license or passport number. So There is some current requirement, but it's sort of haphazard, and uh, the 20 employee threshold is, in my opinion, just utterly arbitrary. And one of the weirdest things about this whole series of legislative proposals is that it lets huge parts of the business community off if they're relatively large and more able to deal with it, but imposes these burdensome and ambiguous requirements on the smallest businesses in America, those least able to deal with it, and also probably pose less of a threat.
One other thing to add on that, even if you are an exempt entity in this bill, if you own or have a large stake in a subsidiary, and that subsidiary otherwise meets the definition of who has to report under this bill, those entities still have to report. So I think that's also something where entities who think that they are completely exempt under this bill, there would actually be reporting obligations. You think of a bank or anybody that might own or have a stake in thousands, of LLCs or subsidiaries, there's still reporting obligations under there that I don't think are quite realized yet.
This gentleman here, and from now we have a mic, so if you could just speak into the mic.
I'm Clay Fuller from the American Enterprise Institute, which I've written on this a little bit. Thank you for the event. This is very informative. I think I agree with all of you on a lot of the concerns, especially on the beneficial ownership definition, the 60-day requirement, and the punishment. I think those are issues, and I think you've all outlined potential solutions for those as well. That I think the CDD requirements coming out in May from Treasury could easily be applied to the definition and put in there. But I take a sort of larger picture, bigger approach to this, where I see the public registries that are going through in Europe and how Europe is heavily cracking down on this issue that's forcing a lot of this illicit money into American markets. And so I think you make a very strong point that money launderers are going to move into partnerships and trusts. And this is like the kleptocracy initiative. I've already shown that money launderers in the United States are already moving into trusts and partnerships as well. So my question would be, instead of just not going after them, why not include trusts and partnerships in the legislation after fixing all these other problems? And then also, I'm very sensitive to small business interests, as my wife was a small business owner until the local county government put her out of business through eminent domain. So it seems in this current environment of foreign influence and illicit money, terrorist financing everywhere, it would behoove or would benefit small businesses to actually be able to certify themselves as we are clean. Right? If there was some kind of way to go through and they would be able to say, we are not involved with any type of nefarious actors, it would actually increase competition and actually benefit them in some way if you're able to fix other problems before. Thank you.
Go ahead, and then I'll add some.
Sure. So two things. So one, and this is something that came up in the House Financial Services hearing as well, of one of the members raised that, hey, we already have a Form 1065 of partnership income where information like this is already reported. Can't we figure out a creative way to use information that the government is already collecting, where law enforcement and FinCEN and everyone can get together and target where exactly blind spots are within the system? So I think we would say that thought is a much better approach, as opposed to kind of the blanket, collection that's embodied under these bills. So to your question about partnerships and trust, that was something that was raised at the Financial Services hearing. The second point, since you raised the public registry issue, which have sprouted up around Europe, one thing I do want to be clear is under S 1454, which is the White House beneficial ownership bill, where the collection mechanism is done through each individual state. Nothing in that legislation would supersede any state right-to-know law or state sunshine laws. So if you are in a state that has sunshine laws where basically says that type of information has to be made public, you could end up if that bill were signed into law, you can end up with a lot of this information out in the public domain. And you can imagine why that's a big deal, particularly for venture capital, angel capital, other investors, and why that's a problem.
Let me just say something on this subject more generally. I've been doing this for a while, and for at least 40 years, we've been increasing the AML, Bank Secrecy Act, Know Your Customer rules every 2 to 3 years, and both at the national and international level. And basically, the FinCEN guys come in and say, money launderers, drug dealers, terrorists, and then Congress says, okay, we'll make more rules. I mean, for example, financial institution doesn't mean what you think it means. It includes car dealers, jewelry stores, on down the line. But the long and short of it is we now have this massively complex, burdensome system that falls largely on financial institutions, but elsewhere. And there's been almost no meaningful effort to see whether there's any kind of significant benefit for the massive costs that have been imposed. A colleague of mine, Norbert Michel, and I wrote a paper in September that I believe provides the first quantitative estimate of the cost of the AML compliance regime. We came up with numbers based primarily on OMB paperwork estimates monetized of $4 to $8 billion. If you get into the details, you realize that the 3 government agencies that track AML convictions have radically different data, which means, of course, the data is sort of junky. But what they also do not report is whether any of these AML convictions are standalone AML convictions or just add-on counts when they got somebody for a predicate crime like drug dealing or terrorism. My suspicion is that the overwhelming majority of AML convictions are when they got a drug dealer some other way, and then they just threw on an AML count, which means at some level that you may have as few as tens or a few dozen AML convictions that are in any meaningful sense true AML convictions as opposed to add-on accounts, for which we're paying $4 to $8 billion a year, which means, if you do the math, that these are massively expensive rules that are doing relatively little good. It's time that the data gets cleaned up. It's time that the government be forced to provide some sort of cost-benefit analysis. If you go and look at the CBAs in the proposed rules, they basically throw in all kinds of, verbiage about intangible benefits and this and that, but there's no real data there. So it's time that policymakers become skeptical about this ever-increasing burden and actually demand that FinCEN and other government agencies prove that there's some benefit to all this, because it's becoming ridiculous. It's becoming to a point where banks aren't willing to open accounts for small people, either individual account holders with small balances or small businesses. It's become extraordinarily expensive to the point where community banks are beginning to fall behind, and we have an increasing concentration in the banking industry because of the ever-increasing burden of AML and other kinds of compliance. And lastly, while any one of these rules, this rule strikes me as one of the most boneheaded rules proposals I've seen in a very long time. And I don't say that casually because I look at a new 300 to 500 page rule every couple weeks. But it's not just any one rule. It's the constant accretion of rule after rule after rule after rule. And then we wonder why the economy is growing slowly and why startup businesses are declining. And if you look at the numbers, the level of startups or business entrances are down compared to where they've been historically, and exits are up. And this ever-increasing regulatory burden is part of it. And the last thing we need to do is make it worse, substantially worse. This gentleman.
Hi, I'm John Bloom with the House Financial Services Committee. I just had a quick question. Brian, you touched on this earlier, but I was kind of wanted to get everyone's opinion on the incoming CDD rule and its effects. They are going to be required to provide some beneficial ownership information to financial institutions as part of their customer due diligence requirements. So that's it.
Yeah, I think two things. One is when we're looking at the CDD rule, the contrast in definition. So the CDD rule, essentially a max of 5 individuals that the business would have to report. So you have the one controlling person, and then anybody that owns a 25% equity stake. You can argue over whether 25% is the right threshold, and I know maybe some banking organizations are actually asking for a lower threshold in order to gather more people. But we think that kind of finite approach and that tighter definition is much more preferable, putting aside all the other issues with the CDD rule. I think from a definition standpoint, the approach taken in the CDD rule, which FinCEN, of course, spent years developing and getting public feedback on, we think that approach makes a lot more sense than the vague definition that's included in some of the proposals.
And I would just agree that, regardless of the thresholds, as long as a business or someone who's required to follow the reporting rule can understand what the rule is, then they can comply with it. And that's really the strength of the CDD rule versus what we're talking about here. Here, there's just, you can do your best guess and hope you get it right. The other thing I would mention is that when we're talking about FinCEN regulations under the Bank Secrecy Act, criminal penalties attach generally with willful violations. And that typically means when I am aware of the rule and I on purpose try to break the rule. And that is a much stronger protection than what we're talking about here, which is simple giving false information consciously, whether or not you were aware of its falsity. And so I think those are two very distinct issues. And that's why, at least from our perspective, the CDD rule is far preferable.
I guess the last thing, I just add a couple thoughts. In principle, FinCEN has expressed a willingness to revisit some of these rules with the regulatory burdens and costs in mind in a way that perhaps would not have been the case under the previous administration. Or whether they'll actually end up doing that or not, I don't know. But it would seem to me that the focus should be improving those rules, and rather than adding a whole new, extraordinarily burdensome, ambiguous set of requirements, I simply fail to grasp the logic of the CDD rules are a problem, so let's make the whole problem even worse by adding a whole new pile of rules on the smallest businesses in America. In the back in the blue jacket. Well, yeah, I met the gentleman sitting, but then we'll go to you, sir.
Okay, all right, sorry about that. Rick Weber, Inside Washington. I was wondering if you could cast this whole issue, the proposed reporting requirements, into the reg reform debate. If there is bipartisan support for some of these proposed requirements, how do those Republicans reconcile the broader regulatory relief agenda? I mean, is counterterrorism sort of butt up against reg reform? I don't know if that's sort of baiting the witness here.
Yeah, I would say maybe if you take the House Financial Services draft as an example, outside of beneficial ownership, there's a lot of other things in that discussion draft, raising thresholds for SAR reports and that sort of thing, which are items that haven't been updated in decades. I think there is a lot of bipartisan interest in updating a lot of the BSA AML regime, and you saw a hearing in Senate Banking this week. Obviously, the hearing on the House side, you are seeing a lot of bipartisan interest in that entire regime. But as I mentioned at the outset, on the specific beneficial ownership piece, there's also been bipartisan opposition for years in terms of the creation of a government reservoir of all of this information. So seems to me that is kind of the sticking point in all of this, or going to be one of the sticking points in all of this. But it's definitely, if you look at the priorities of the relevant committees, this is pretty high up there. I think the sticking point of beneficial ownership, yes, being a question of, okay, we understand there's issues with the CDD rule. Are people comfortable basically shifting the burden to small businesses? And that's where we've had the issues with the proposals being put forward.
None of this legislation has massive support in the Congress, although it is bipartisan support and opposition. The gentleman standing in the back.
Thank you. My name is Sanjay Srikanti. I'm a financial advisor with Morgan Stanley. So this topic directly affects my industry. I missed the first 10 minutes. I just wanted to ask Brian about where each of these two pieces of legislation or potential pieces are in the House and the Senate. Thank you.
Yeah, so there's two relevant bills in the Senate. There's S 1454, which is Senator Whitehouse's bill, which is beneficial ownership bill, and that would involve collection through states. And then there's the Corporate Transparency Act. I can't remember the number, but it's a Senator Wyden bill. Neither of those have had even a hearing yet. And in fact, the White House bill is the former Carl Levin bill, which has been around for 8-9 years. The furthest that has gotten in Congress was there was one hearing in 2009, I believe. So those bills in the Senate have not even been marked up. Where it stands in the House is in a discussion draft stage. They had a hearing on a discussion draft that included beneficial ownership provisions as well as some of the other BSA AML pieces that I mentioned back in November. And so I think they're exploring what the next steps are there for introducing a bill and then moving it. So nothing moving quite yet, but hearings and a lot of discussions.
Mark. Yes, thank you. Right here. Yeah.
Yeah, my name is Mark Boschetti. I'm a reporter for a news organization called MLEX, and I actually cover a lot of corruption and money laundering cases. And the whole thing kind of puzzles me because I've never seen a money laundering case where a butcher shop or a bakery or anything like that changed hands. So my question is law enforcement actually asking for this bill? Either local law enforcement or the state police in Connecticut or the FBI or any other agency that really needs to go after people in corruption cases and money laundering cases? Thank you.
Well, I've certainly heard a lot from law enforcement that they're asking for this information. And the refrain seems to be consistently, we always want more information. We will do whatever we need to do with more information. And I was in a hearing yesterday where former FBI, I believe it was the former chief of the financial crime section for the FBI, was testifying as a witness. And he was very clear that it is important to law enforcement to gather as much information as possible on whatever they want. And as I mentioned before, I think a lot of the perspective from law enforcement and from the prosecution is this is really all about leverage. Because I think you're right. We don't typically think of mom and pop businesses as being money launderers. And I don't think that's really how they would be using these bills. But I think what they would do is go, it's leverage. You can go after really anyone you want to, because chances are, with all of the regulatory burden that any business has and any of these rules, law enforcement can find a violation if they want to. And so they can investigate someone really for any reason and sort through the information, and odds are they'll find some technical violation that they can then use as leverage.
Ammon Simon with Senator Sass's office. Let's assume, for the sake of argument, that law enforcement has a real need to get beneficial ownership requirements. I'm trying to think through what is the way to allow for that information to get to them without imposing significant burdens on Main Street businesses. Would it be workable? Maybe it isn't, but would it be workable to perhaps require businesses to provide that information upon request? Perhaps if law enforcement has some sort of reason to believe that there is an issue. Is that something that could work, or does that still pose problems, or would that help law enforcement?
Well, certainly to the extent that law enforcement has a legitimate need for this kind of information, it's widely available to them already. When we're talking about financial records and all sorts of records that are required to be generated under the Bank Secrecy Act, for example. Financial institutions, which are broadly defined to include all sorts of businesses, have to maintain all sorts of records. And government entities can request those and investigate them when they have a particular investigatory need. And so I would push back on the notion that law enforcement has really a limit that exists now to be able to get information that they need. I don't think I've ever heard law enforcement tell me a specific example of when they were trying to get information and they just had no way of getting it. I think there are plenty of ways to get at the information, but this is really just about putting the burden on businesses to provide the information up front so that law enforcement can have it to look through if they want to. And I think that's sort of backwards of where we want to be. We want to have investigators looking at someone for a reason, and if they have a reason, they can get the information they need.
And David said in his opening comments too that I think the information that is necessary is already something that is filed and that businesses are filling out. And I think in a lot of our discussions with law enforcement, whereas and they have a very difficult job here, and kind of the default position sometimes is give us all of the information. But if you can say, hey, if we can give you 1 or 2 or 3 live human beings that are associated with this entity that you can go corner and question, they'll typically say, and in fact, the witness at the House hearing back in November basically said this, that is something to at least give them a start into their investigation and is oftentimes sufficient. And if I could maybe answer just respond to the last gentleman's question as well in terms of, who would really be targeted on this. Sarbanes-Oxley Act in 2002 had these anti-shredding provisions that basically made it a federal crime to shred documents at certain companies. There was a case that went all the way to the Supreme Court a few years back where a Florida fisherman was stopped by Florida Fish and Wildlife off the coast of Florida, and he was 6 grouper, something like that, over his limit, and they escorted him back to shore. And by the time he got back, those 6 grouper had magically disappeared. He was prosecuted under the Sarbanes-Oxley anti-shredding provisions. So if you give law enforcement or if you give federal prosecutors these broad tools that apply to millions of Americans, you kind of never know what you're going to get. So I think it's something to be cognizant of.
All right, we might have time for one more question. Kyle.
Hey guys, Kyle Hoppman with Senator Cotton's office. I totally agree with you. I think there's a sentiment we don't want to move from where we are today, where the financial community is being treated like outsourced law enforcement. We don't want to move from there to a world where we're hurting Main Street businesses. And you agree, the venture capital business is one of America's best strengths. But let me ask you this. I feel like we might need something that allows the government to find out who owns a condo in Chicago for you. There is a sense that dodgy folks are stashing money in the U.S. and they feel like, you're the sheriff trying to look for a fugitive. It's kind of embarrassing if the fugitive's hiding in your house and you didn't know it. That's how they feel right now. So I feel like we don't want to make every single business in America get these letter in the mail and that feeling of dread. Right now, it's like these DC traffic cameras. Instead of saying, they're sending a letter, the suggestion is to send every single motorist on the camera, prove that you were not violating the law. That's the wrong way to go. But I feel like they need something. They want to find a new tool they don't have now. That Russian that bought that $40 million condo, they'd like to get a name of a live human. I think they need something, and that might be the path forward. Because people, I think, do want to do something on AML, partially because every single state banking association is pushing them to do it. So anyway, my question was solutions. If there's something, you could throw us a bone, come up with a way that they don't have now where we can say we made progress towards finding out these actors who are stashing money in the United States. Any ideas on that?
So I would say, we are in kind of not an ideal situation where banks have been deputized to basically be the deputies out there and enforcing a lot of the laws. Just going back to what we were saying earlier about can we leverage the existing information that we have, and this is something where obviously law enforcement needs to be very involved, FinCEN needs to be very involved on targeted solutions for this. And I don't have the answers right now. I think now that these bills are really gaining a lot of attention, I think it's something that we have to everyone sit down at a table and figure out what targeted tools do you need? Because, you know, the blanket approach where all the good guys have to comply while the bad guys still get away with it is not going to work.
Well, let's just think out loud about what is required under current law there, right? First off, the real estate records are public record. Secondly, for that LLC to have opened a bank account, they had to have provided a whole bunch of information to the financial institution that provided the bank account. That's available to the government. It may not be on somebody's PC they can look up immediately. To be honest with you, they probably have to go to the bank and ask. And then the second thing is the LLC or corporation, if assuming it's an entity, that information is at the IRS. Now, we all know that the IRS's computer capabilities are, shall we say, a bit behind the curve. But the fact that the government is unable to talk to itself really shouldn't justify this massive burden on small businesses in America. Unable. The tax information is there. And the 1065s, or if it's a S1120S, is in the IRS's computers, and the K1s tell you who owns it in a tax sense, who owns it, right? Not this sense where anybody who has any control is treated as an owner, so on and so forth. And so that information, to no small degree, is there. Now, they're going to have a tax number instead of a passport number, but I don't think that's a big problem. So some of this is the government actually getting its act together, and the IRS being able to talk to the guys down the hall at FinCEN and vice versa, right? The other thing is C corporations. I mean, there is a bit of a thing. There's C corporations would have to file 1099s if they pay dividends to the owners. If there's no cash that changes hands in a C corporation, then there wouldn't be a 1099 unless it's held through the medium of a broker. So a closely held C corporation that doesn't pay any dividends to anybody is probably the only way around the tax information allowing law enforcement to do it. That's a fairly narrow group, and maybe you could address that. But I think the big problem is that the guys at the IRS can't talk to FinCEN, and FinCEN can't talk to the IRS. I mean, it's basically ineptitude within the Treasury Department.
And I would just echo the sentiment that it's really about being careful. Whether law enforcement needs the information or not, wherever they get it from, that's not really, at least my concern. My concern is that the people we're asking for information, that they know what information they're supposed to provide, and then when they do their best, they're not going to prison for it. And so it's really just about being considered and being careful about what the solution is, no matter what that solution is. And so that's really where we're at.
And just because law enforcement wants it doesn't mean it's worth doing. If it ends up costing $100 million per conviction, you have to ask yourself, is that a useful, or I mean, is that sufficiently beneficial way of spending $100 million, or would you rather spend that $100 million some other way, feeding the hungry, or take your pick? There has been almost no serious analysis of the costs that these rules are imposing on our society, and that's true in academia or elsewhere. And it's time we started looking at these costs, because they're way beyond small. They're very, very large. And just because somebody in law enforcement or somebody at FinCEN says, well, it'd be really nice to be able to sit down on my PC and get this information instead of have to ask for it, doesn't mean it's worth another $1 billion or $2 billion. It isn't. All right, well, thank you very much. I'm sure that our two panelists, and certainly myself, would be glad to communicate with anyone that has additional questions, and we look forward to working on this issue as we go forward. Thanks again.